Hello everyone, welcome to our online talk which will begin in a couple of minutes. For the time being, I'll be playing this short video.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome everybody. Thank you for giving us your time this midweek afternoon. My name is Jasmine Wong, and I'll be your moderator for today's session. Today, we will be hearing directly from Jeremy Balang and Fong Carmen, who will be speaking on medical negligence claims, what patients and their families need to know. For some of you who are already our regular attendees, you would have heard and know all about us. But for those of you who are actually attending our online talk for the very first time, allow me to introduce the firm and a little about what we do. Now, we are a mid-sized law firm that was founded back in 1985 by Datuk Ma Peng Kuai, who is now a retired Court of Appeal judge. We have grown since 1985, and today we actually have 28 lawyers and a support team of 35 people. We are a full-service law firm with a corporate department, dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment law and industrial relations department, and a department focused on servicing the needs of individuals and families. We work primarily with small, medium enterprises, family businesses, and individuals. So today's talk is part of our MWKA online talk series. A little bit on the background is that we have actually been organizing monthly lunch talks at our office since 2013, some of which was actually broadcasted live. But with the COVID-19 pandemic and the movement control order, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. So today, you'll be joining us on our 8th talk in our online talk series this year. And now, moving on to our first speaker of the day. Jeremy Balang is our senior associate practicing in the areas of medical law, personal injury, debt recovery, and general litigation. Jeremy has extensive experience in various medical and dental negligence claims, acting for patients, hospitals, healthcare practitioners, and insurance companies. Our second speaker, Fong Carmen, is our associate from our dispute resolution and individuals and families department. Carmen has experience in general litigation, debt recovery, probate and administration of estate, corporate and commercial litigation, and Carmen also specializes in joint management body matters and family law matters. So our speakers today will be covering the following top points: obtaining discovery of medical records, seeking independent expert medical opinions, grievance mechanism, disease patients, limitation periods, the types of damages claimable, together with interest rates and legal costs. With that being said, I will now pass the floor to our first speaker, Jeremy.
Thank you, Jasmine, for the introductions. Good afternoon, everyone. Today, we'll be talking about the two aspects to a medical negligence claim, the liability aspect and the quantum aspect, and what patients and their family members need to know in respect of both aspects. I'll be discussing issues relating to liability, whereas my colleague Carmen will be addressing issues relating to quantum. Medical negligence is itself a subset of the tort of negligence, and there are many examples of actions or omissions that may constitute medical negligence. There are three broad categories to it: negligent advice, negligent treatment, and negligent diagnosis. Those are just the larger categories. There are many other smaller areas that would amount to actions or omissions that would be considered medical negligence. And like any claim in tort, there are three basic requirements in order for a claim in medical negligence to succeed. First, that there exists a duty of care, which is owed by the healthcare provider and or the practitioner to the patient at the material time. Two, that such duty of care was breached by that healthcare provider or practitioner. And finally, that such breach had caused or materially contributed to the harm or injury suffered by the patient. Now, the first criteria deals mainly with the duty owed by a doctor or the hospital to the patient. And the law in this regard is well settled. Doctors do owe a duty of care to their patients, and so do hospitals. In fact, the term is commonly known as a non-delegable duty of care. Now, the second aspect deals with whether or not there was negligent treatment provided. Now, this concerns instances where healthcare providers and practitioners fall below a certain standard of care and so have breached their duty to the patients. Finally, the third requirement deals with the causal connection between the breach of the duty of care, i.e. the negligent treatment provided, and the harm and injury suffered by the patient. So there must be a causal connection between the two, and the three together taken constitutes the necessary elements to succeed in a medical negligence claim. So let's talk about the very first aspect of liability when it comes to medical negligence claims, and that is medical records. So there are a number of concepts, issues, and in fact, misconceptions regarding the use of medical records in medical negligence claims. So the three being shown on the screen right now, let's go over them one by one. Yes, medical records play a very important role in medical negligence claims. There are some cases that have been reported where patients have succeeded without, but those are very fact-sensitive, special to their circumstances. All in all, the courts do consider the medical records as vital insofar as the evidence is concerned. Second, no, medical records are distinct from a medical report. A medical report is on its own often not enough in order to prove either liability or causation in a medical negligence claim. And finally, no, a medical report is not the same as an expert report. So let's take these three together and talk about the difference between, say, medical records and a medical report. The fundamental difference between the two concepts is that medical records are contemporaneous. They are contemporaneous evidence, meaning that they were created at the time of the material events. So when a patient walks into a hospital, is attended to by a doctor, that doctor writes clinical notes. So too does the nurse who attends to that patient with the doctor. The person is sent to a lab to undergo various blood investigations, MRI investigation. Those create laboratory reports, imaging scans. The patient for some reason requires intensive care and is admitted into the ICU. That creates ICU clinical notes, ICU charts, etc. The list goes on and on. So those records are created at the time. Now, a medical report is distinct because it is prepared well after the clinical events. And it is something that hospitals often provide for patients upon request, provided that the patient pays a certain fee. The medical report itself is prepared by, say, the treating doctor to that patient with the aid of the medical records themselves. And it need not be prepared for just the purpose of a medical negligence claim. It can be prepared for insurance purposes, to aid in a criminal investigation, to assist in the treatment by another doctor who's taking over the management of that patient. There are a multitude of reasons. But insofar as a medical negligence claim is concerned, the courts of what is contemporaneous evidence and what is in a medical report, though a medical report would contain relevant evidence. Now, so the best way to show this is to look at the case of Tindok Besar, right? This is a federal court decision, and I'll read out the relevant parts. I, with respect, feel somewhat safer to refer and to rely on the acts and deeds of a witness which are contemporaneous with the event and to draw the reasonable inferences from them than to believe his subsequent recollection and version of it, particularly if he is a witness with a purpose of his own to serve and if it did not account for the statements in his documents and writings. Plausibility should never be mistaken for veracity. Now, a medical report is something that the doctor usually prepares upon a request. And when the doctor receives the request, sometimes it comes through lawyers and he realizes that there's a possibility that he may be sued. So when he prepares the report, he's not going to say everything that should be said or what would say be reflected in the records. There are only a very few instances where a doctor would actually admit to, for example, wrongdoing in a report. So that itself is something that the courts will consider when looking at a medical report. Now, a case that best demonstrates this issue is the case of Nur Azlin, right? So in this case, the patient was a Malay lady who needed to undergo spine surgery to correct scoliosis in her spine. Scoliosis is itself a curvature of the spine. So during the procedure, a number of pedicle screws were inserted into that patient's spine in order to correct the scoliosis. Unfortunately, the patient later developed paralysis of the lower abdomen. Now, the patient asserts that she was never told of this risk of paralysis. The doctor says that they did. They said, however, when the medical records were disclosed, there was no mention at all of any risk in respect of the treatment. But the doctors insist that they did give it. Simply because they did not write it down does not mean that they did not give it. When it came before the High Court, I dismissed the claim, stating that simply because it's not written down does not mean it was given. The matter went to the Court of Appeal, and this is what the Court of Appeal said. On the facts in the present case, the plaintiff has successfully proven that the defendants had failed to inform her and her parents of the risk of paralysis. This is based on the fact that nowhere in the consent forms or the clinical notes of the plaintiff was the risk of paralysis, or for that matter, any risks mentioned at all. We feel that in the absence of any documentary evidence in support of the defendant's case that the risk of paralysis had been informed, the learned High Court judge should not have made any assumptions and arrived at such a simplistic conclusion. To put a long story short, the medical records are something that are absolutely needed in the records, but whether or not you need them to succeed in the case, that would depend. Certainly the courts will, even the efforts to obtain medical records would itself be relevant. And it's very difficult to rely entirely on just a medical report in order to succeed. Now, going back to my earlier slide, the third point in that first slide, the point about a medical report being not the same as an expert report. A medical report is prepared by the treating doctor. That is factual evidence. So that would be considered a factual evidence. An expert report is prepared by an independent expert engaged by the lawyers to give opinion evidence. The courts give very different weight to these two. And insofar as the standard of care is concerned, the court will consider opinion evidence, and a treating doctor cannot give opinion evidence for the simple reason that doctor is not independent. More will be said later about the second aspect in the next issue. And in fact, this is a further passage in the Nur Azlin case, and I'll read that part out in paragraph 66 of the reported judgment. With respect, we are unable to agree with the approach taken by the learned trial judge. Such an approach downplays the importance and purpose of the consent form, as well as the importance of the duty to warn patients of the inherent risks of the proposed treatment. Moreover, such a liberal approach by the court is open to abuse by medical practitioners. Once again, it emphasizes the importance of medical records, which serves as contemporaneous evidence of the clinical events. That being said, a medical report is itself relevant evidence, and the court will give it weight accordingly. Now, next question is, how do you obtain the medical records? Sometimes it can be as simple as your lawyers writing in, or even the patients themselves making a written request to the hospital seeking copies of their records. Some hospitals make voluntary disclosure, some do not. Some will give you the whole set, provided that you pay the photocopying charges. Some insist that an order of the court is needed. So Order 24, Rule 7A of the Rules of Court provides for an application for pre-action discovery. This may be filed in court in order to compel the hospital to disclose copies of the records, and the cost of such application may be included in a claim for medical negligence later as an item of special damages. Now, in the past, there was no such thing as Order 24, Rule 7A. In the past, most patients who would file the suit and obtain pre-trial discovery of the medical records. But by the time it's too late because the suit is well filed and one can only know what surprises lie in the medical records. So Order 24, Rule 7A allows claimants to look into their case before the filing of the suit, which leads to a great saving of time and costs. Let's move on to the second issue, seeking independent expert opinion. Now, once again, there are a number of issues and concepts in relation to that. So let's start with the first one. Yes, engaging and obtaining independent expert opinion is often crucial in order to succeed in a medical negligence claim. Sometimes you may need more than one expert in a case. You may need an expert for liability. You may need an expert for quantum insofar as a patient's prognosis, future needs, and costs are concerned. Some liability cases, you may need more than one expert. I've seen cases where there are up to 3 different specialties involved in liability alone. Some prove liability, some talk about causation. The second issue, no, it is not the case that you need expert evidence in every medical negligence claim in order to succeed. Definitely, it will depend on the facts. For cases that involve the doctrine of res ipsa loquitur, where the negligence itself assumed, you do not need expert evidence. If the negligence is itself so obvious, or the evidence, for example, the medical report is so damning in its own, there's a possibility that you may succeed without the need to call an expert. And finally, as we mentioned earlier, a patient's treating doctor cannot give expert evidence in a patient's case. What that doctor can do is be called as a witness to give evidence regarding his findings as the treating doctor. So if, say, a patient undergoes surgery at one hospital, but develops considerable complications later, goes to another hospital and undergoes remedial surgery by a different surgeon, that surgeon may produce a medical report, and that surgeon may also give evidence about what is said in that medical report, which is itself relevant evidence. But the courts will not consider that doctor giving opinion evidence for the simple reason that he is not independent. He treated the patient. So to the next set of issues, yes, there are doctors who are willing to give expert evidence against their fellow doctors, although they are not always critical in their opinions. In fact, the late Gopal Sriram in a Court of Appeal case had famously said that it is repute that doctors make the most reluctant witnesses against their brethren. But that being said, there are doctors who do. Next one. Yes, an expert is likely to charge a fee for preparing his or her expert opinion, and also for attending court, and that fee is determined by the expert. No, an expert must be paid his or her fee regardless of whether his or her opinion is supportive of the claim. This may include cancelled court attendance, the bane of every lawyer who has ever done a medical negligence claims, especially during the COVID-19 pandemic. It is the expert's prerogative as to whether to reduce his or her fees and to waive it. And yes, the expert's fees may be claimed later in the suit. Now, when a patient engages an independent expert, there is no guarantee that expert will say what the patient wants. The point is that the expert is independent. He or she looks at the records and determines the merits on its own. It could be good, it could be bad. Experts too have their own opinions. So this is an expense that a patient must be willing to be ready to pay. But of course, if a case itself bears enough merits on the face of it, then that increases the chances of the expert coming to the same conclusion. Now, it is the case that not every case needs expert opinion. In fact, insofar as the standard of care that is applicable to doctors, the reason the expert evidence is needed is simply because the courts in Malaysia apply the Balang test, whereby a doctor is found to have fallen below the standard of care if, say, it's not found to be negligent if there's a body of medical opinion supporting the treatment and management that he had provided to a particular patient. That being said, the Balang test has itself received a number of narrowings from the Bolito qualification, which says that the court can reject expert evidence if it does not stand up to logical analysis, it must be reasonable, etc. And the Balang test itself does not apply to various aspects of medical negligence. A perfect example is in this case. So in this case, TEBT, it concerned a patient with cancer. So following a biopsy, the doctor in this case had described the cells to be round and polygonal in shape. when the cells were in fact thin and spindle-shaped. And as a result of the way that this doctor had described the shape of the cells, there was a delay in diagnosing the patient's cancer in this case and caused her to suffer harm. Now, the High Court in this case had rejected the use of the Balang test and stated as follows. Further, another obvious mistake made by the first defendant, which did not require any special skills, is to determine the shape of the cells tested under the microscope. The first defendant described the cells as round or polygonal, when in actual fact it is spindle-shaped and no special skill is required to determine the shape. So it is in these kind of instances that you do not need expert opinion per se. You don't need it as well for issues relating to findings of fact, the provision of advice and information. These are not things that require an expert to come to court and to support or to criticize. That being said, it is still almost always the case that a plaintiff is required to prove their case, and that is usually done through expert opinions. Now, let's talk about a number of other issues concerning liability, and I accept that I cannot cover everything in this talk, so I'll cover what I can, the pertinent ones. For example, the issue of liability. The issue of limitation is complex. For any patients who are watching this talk, always talk to a lawyer to consult about the limitation periods, because in some instances, it's very simple. If you're an adult patient suing a private hospital or healthcare practitioner at that hospital, it's 6 years from the date of the act. If it's a government or a university hospital, it's 36 months from the date of the Tortious Act. These are straightforward ones. If, let's say, the patient is a minor, less than 18 years old, I give an example. A 5-year-old boy receives negligent treatment at a hospital and he wants to sue. The limitation will only run when he reaches the 18 years old, and then it's either 3 or 6 years, right? And there are cases to approve this. Now, there are cases where a patient is both a minor and who has suffered permanent injuries. A common one is a patient with cerebral palsy. The limitation period would then never run, as the patient never ceases to be under his or her disability. So a case that exemplifies this is the case of Indadu Rahman. Now, in this case, the patient was born at a hospital in Penang that has long closed in 2007. He was born with a brachial plexus injury, so his arm got caught in a vaginal canal during the delivery events, causing harm to the shoulder area and to the arm. The suit itself was filed almost 12 years later. Both the hospital and doctors sought to strike out the claim on the ground that it was barred by limitation. They said that he had only 6 years. The High Court dismissed the striking out application and said as follows. Since the minor in the instant case had yet to reach his age of majority, time for the purposes of the period of limitation is yet to commence. Time will only commence on the minor's 18th birthday. Now, if you thought this was complicated, it gets even more complicated if the patient is a deceased patient, because then there are two kinds of claims, a dependency claim or an estate claim. And the facts are on the screen, but these are concurrent limitation periods, meaning that there's more than one limitation period applicable to that particular cause of action. Always seek a lawyer's advice. Even the advice here will have to be examined upon the facts itself, right? And other points in regard to deceased patients. If a dependent, let's say a child of the deceased or the spouse, for example, they wish to sue as the administrator of the deceased patient's estate, he or she would need to apply for grant of letters of administration. This is where there's no will left behind. If there is a will left behind, the dependent will need to apply for grant of probate. Now, a dependency claim is very different and distinct from an estate claim. A dependency claim is where you sue as a dependent of the estate, whereas an estate claim, you sue as if that this person's own right, as if that person were alive. So in an estate claim, there are a number of items you can claim which cannot be claimed for in a dependency claim. For example, pain and suffering and loss of amenities of life, aggravated damages. In law, there's a common concept of suing as both a hybrid claim as a dependent of the deceased and the administrator of the estate. Finally, insofar as liability is concerned, and insofar as private hospitals are concerned, there is something called the Grievance Mechanism. Now, the private healthcare regulations provide that if a patient or his lawyers were to inform the officers of the hospital, or more specifically the patient relations officer, of his or her grievance regarding the treatment and management of his or her case, the hospital is required to provide a reply to such grievance in no less than 14 working days from receipt of the grievance. And the reply is to include the results of the investigation undertaken by the hospital in respect of the grievance. There are different regulations applying to private hospitals and to, say, private clinics, including dental clinics. You would have to apply the correct one, but they both basically say the same thing. And as for insofar as government hospitals are concerned, there is a complaint that you can make to the Ministry of Health that works in a similar fashion, but that deals with issues of systems at government hospitals. So that's all from me, investment liability. I now pass the floor to my colleague Carmen to talk about quantum.
Good afternoon, everyone. My name is Carmen, and today I will be addressing the last two top points, which are firstly, the types of damages claimable and interest rate and legal costs. So assuming that a claimant is successful in proving liability against the tortfeasors, the court would then consider the issue of quantum, which is the monies to be awarded to the victim of the tort. The monies awarded by the court are known in law as damages. So for the overriding principle of damages is that it is compensatory in nature, which is to put the victim in so far as it is reasonably possible to do so by the award of monetary compensation in the position that he or she would have been if the tort had not occurred. There are various kinds of damages that may be claimed in court. This includes special damages, pre-trial damages, which are an extension of special damages, and I will explain this in detail later. General damages, aggravated damages, future damages, party and party costs, and interest. This term of pre-trial damages is commonly used to cover expenses incurred during the time period between the filing of the claim and also the date of judgment. The principles applicable to special damages are therefore applicable to pre-trial damages as well. So we'll now move on to consider each type of damages in detail. Firstly, we'll deal with special damages. Special damages are damages that can be quantified with some precision. So in the case of Nurul Husna, special damages was described as the actual pecuniary damage or loss suffered between the date of the negligent act and the date when the court delivers the judgment. Some common examples of special damages are hospital or medical expenses, the cost of purchasing medications, supplements or special foods, the cost of therapies or traditional treatment, your traveling expenses, the cost of purchasing equipment or appliances, the cost of engaging a carer or a maid, etc. We'll then move on to consider some of the concepts regarding special damages. One of the common questions we receive is, are special damages recoverable? The short answer to this is yes. Special damages are recoverable as long as they are justifiable in the circumstances and also for a reasonable sum. In the case of Rogetana, as shown on slides, the Court of Appeal similarly held that special damages were to be allowed so long as they were within a reasonable sum and justifiable in the circumstances. This will then bring us to the next question. Do we then need a documentary proof of every expense? The short answer to this is no. The court may accept either oral or documentary evidence. It is a bit like unrealistic for a victim of the tort to be able to collect, keep and produce every bill and receipt. For this, I refer to the case of Noor Sharafina. In this case, the High Court held that as long as there is oral testimony to support the expense, and the expense can be reasonably expected to be incurred due to the circumstances of the case, the courts have allowed the claim for special damages. Moving on, when considering whether or not the oral evidence in respect of a claim for special damages is sufficient or not, also a relevant consideration which the court may take into account is whether there was any challenge from the defendant in respect of that particular claim. So if there's no challenge, the court should accept the evidence and ought to take it as true. For this part, we refer to the case of Pantai Medical Center, Sendirian Berhad. In this case, the Court of Appeal took into account the unchallenged evidence by the claimant's wife at trial and maintained an award for loss of earnings of almost 2 million. despite the fact that there was no documents purportedly showing that the claimant's loss of earnings. Next, in order to claim for special damages, such loss is to be specifically pleaded in the statement of claim and particularized. However, as this is a general rule, there will be exception to it. The court is not bound to limit each of the particulars of special damages to the amount pleaded in the statement of claim. If there are evidence to show that the actual damages are more than the amount pleaded, the court may then award the actual amount. This principle can also be found in the case of Mat Yusuf bin Dawood. We'll then move on to consider general damages. General damages are for those damages which cannot be quantified with precision, and so the courts award damages based on precedents, comparable cases, or estimation, usually with the assistance of expert evidence. So some examples of general damages are pain and suffering and loss of amenities of life, future damages, the value of gratuitous care provided to the victim of the tort by his or her family members, and loss of earning capacity. There are two components for pain and suffering and loss of amenities of life. The first component, which is pain and suffering, deals with physical pain as well as emotional distress suffered by the patient as a result of the negligence. The second component, which is the loss of amenities of life, it deals with the loss of one's enjoyment of life as a result of the injury. Some examples may include the interference with one's marriage, social or family life, as well as the loss of enjoyment of hobbies. While the two are distinct components, they are usually awarded in a single lump sum of damages. We'll then move on to deal with some common concepts regarding general damages for pain and suffering and loss of amenities of life. There is a compendium of personal injury awards prepared by the Bar Council and which the court may consider when determining an award of general damages for pain and suffering and loss of amenities of life. However, the compendium is far from exhaustive and the court is always at the liberty to depart from the compendium if the facts warrant such departure. This can also be supported by the case of Abdul Wafir, whereby the High Court had stated that the compendium is not a statutory code, but only a guideline which does not fetter the court's discretion. Quite often, the largest award for pain and suffering and loss of amenities of life are given to those patients who have suffered brain damage or injuries. The reason for high amount of damages is due to the extent of such injuries and how it affects the patient. For an example, an infant who suffers brain injuries as a result of, say, the events surrounding his or her birth often get diagnosed with a condition called cerebral palsy, which is a group of disorders that can impact their ability to move normally in different parts of their bodies. Sadly, many of these infants do not survive or have significantly reduced life expectancies compared to the average person. On the other hand, an adult who suffered brain injuries as a result of, for example, negligent anesthetic treatment may cause him to go into a vegetative state. For these kind of cases, the courts have awarded a range between 400,000 and 600,000 as general damages for pain and suffering and loss of amenities of life in cases involving patients with brain injuries or damage. Moving on, I'll talk about aggravated damages. Aggravated damages is defined in the case of Sambagawali as a species of compensatory damages which are awarded as additional compensation where there has been intangible injury to the interest or personality of the plaintiff and where this injury has been caused or exacerbated by the exceptional conduct of the defendant. Perhaps one of the most famous Malaysian case of aggravated damages in medical negligence is the case of Dr. Hari Krishnan, where the federal court in this case had upheld an award of 1 million ringgit as aggravated damages. In that case, while the federal court did not specifically identify the facts that warrant such an award, from the reported judgment, we can see that the following facts, which may have served as the federal court's basis for upholding the award of aggravated damages in that case. They are the failure by the first defendant to explain or tell the plaintiff that his right eye was blind, and even though the first defendant was aware of the blindness. Second, the removal of the plaintiff's right lens without the plaintiff's consent, and the giving of false hope by the first defendant to the plaintiff in advising him that the eye would regain vision. So since the federal court decision in Dr. Hari Krishnan, the courts have made awards for aggravated damages in the number of medical negligence cases on the following. Such as the delay or refusal to admit liability, especially in indefensible cases. Defendants pleaded and presented a false case, altered medical records to escape liability, unfair or insulting cross-examination of the patient, failure to make voluntary disclosure of medical records, but the examples given are far from exhaustive. The law regarding aggravated damages and its quantification is still a developing area of law. It is not the case that every medical negligence claim will warrant an award of aggravated damages. It is highly dependent on factual circumstances of the case and, most importantly, the conduct of the defendant tortfeasors following the negligent events and how such conduct had worsened the harm suffered by the patient or their family members. For future damages, the assessment of future damages is rather a complex exercise, and in many instances, it requires expert evidence. There are three important features to the assessment of future damages, namely the life expectancy of the patient, the multiplier, and also the multiplicand. The courts are usually guided by expert evidence in respect of the life expectancy of patients, as well as their future needs and the cost of the same. So a practical example of future damages is shown on the slide. Shows that a 5-year-old infant with brain injuries requires physiotherapy once a week for the rest of his or her life. The experts give evidence that a single physiotherapy session at a private hospital is approximately 100 ringgit. So this will be the multiplicand. The expert also suggests that the infant may live till the age of 40 years, which is considerably lesser than the average individual. The multiplier is derived by deducting the expected life expectancy, which is 40 years, from the infant's age, 5 years, which would give you 35 years. Considering these facts, the calculation for future damages for the cost of physiotherapy would be 100 ringgit times 52 weeks, which is in a year, times 35 years, which gives us 182,000 ringgit. I'll show you another example of a 20-year-old Malay male which loses his leg as a result of negligent treatment and so requires a prosthesis. The prosthesis cost, according to the expert, it's around 50,000, and this 50,000 is the multiplicand, and the prosthesis has a lifespan of about 10 years. There's no suggestion that this patient, having lost his leg, would have a reduced life expectancy, and so the average life expectancy is considered as approximately 70.4 years for a Malay male. So if one deducts the patient's age, which is 20, with the usual life expectancy, which is 70.4, you will get a multiplier of 50.4 years. In this case, you consider as 50 years. The prosthesis would therefore need to be replaced at least 5 times. The calculation of future damages for the prosthesis would be as shown on the slides. It is 50,000 for the initial purchase of the prosthesis, 50,000 times 5 replacements, which is around 250,000, and you add both of it together, it brings us to 300,000 ringgit. So this is the future damage for the 20-year-old Malay. The standard of proof in respect of a claim for future damages is on a balance of probabilities, but with a lower degree of certainty, which can be described as a possibility, chance, risk, danger, or likelihood. In other words, the plaintiff need not prove on a balance of probabilities that such future damage will occur. He or she need only prove that there's a substantial possibility, chance, risk, danger, or likelihood that such future damage may occur. We'll move on to the next top point, which I will focus on interest rate and party and party costs. So in addition to damages discussed earlier, a successful claimant may also be entitled to party and party costs from the defendant. Such costs are laid down in Order 59 of the Rules of Court 2012, which includes fees, charges, disbursement, expenses, and remuneration. Order 59 Rule 6 sub 1 of the Rules of Court also provides various factors which the courts are to consider when assessing and awarding costs. Such factors are set out as below: the complexity of the item, skills, specialized knowledge and responsibility required, number and importance of the documents, the importance of the cause or matter to the client. The court may also consider that each litigant is to bear their own costs or that the costs are to be in the cause. The latter is commonly employed at the conclusion of an interlocutory proceedings, and which order simply means that the cost of interlocutory proceedings shall be awarded to the party who succeeds at the conclusion of the main suit. The courts may, in certain circumstances, even make a Sanderson or a Bullock order. A Sanderson order requires an unsuccessful defendant to pay the cost of the successful defendant instead of the plaintiff paying the cost to the successful defendant. A Bullock order entails the plaintiff paying the cost of the successful defendant and then claiming from the same unsuccessful defendant. Do take note that the orders described above are non-exhaustive, and there are many other cost-related orders which the courts are empowered to make. Having discussed the issue of damages and costs, we will now move to interest, which is something that a successful claimant may be entitled to. The law applies various interest rates to be applied to various types of damages, and the accrued interest is taken into account when payment of the damages is made. The rationale behind awarding interest is to compensate the plaintiff for being deprived of the use of the money which they are entitled to. So there are basically two types of interest. One is pre-judgment interest and another is post-judgment interest. For pre-judgment interest, Section 11 of the Civil Law Act 1956 allows interest to be awarded on damages for the period between the date when the cause of action accrued and the date of the judgment, i.e. the pre-judgment period. The rate of interest is at the discretion of the court. So for pre-judgment interest, the usual rate is 4% per annum on special damages from the date of the incident to the date of judgment, and the rate of 8% per annum for general damages from the date of service of the writ to the date of judgment. As for post-judgment interest, it is calculated at the rate of 5% per annum from the date of judgment to the date of payment. And this is going by Order 42, Rule 12 of the Rules of Court 2012, as well as Practice Direction Number 1 of 2012, issued by the Chief Justice. Order 59, Rule 24 of the Rules of Court 2012 also provides that the interest on costs awarded should also run at the rate of 5% per annum from the date of judgment to the date of payment. So to conclude my top points, these are the types of damages that are claimable and applicable in a medical negligence case. To briefly conclude, the type of damages claimable would then depend on each fact and circumstances of the case. With that said, I will end my talk here, and I will now pass the floor back to the moderator, Jasmine. Over to you.
Thank you very much, Jeremy and Carmen, for sharing with us. I hope that our attendees have learned a little more on your rights and remedies in a medical legal claim. For those of you who wish to ask any questions to the speakers, you can actually drop the questions in the Q&A chat at the bottom of the screen. Now moving on to the first question that we have. Carmen, can a person claim legal fees incurred as special damages? The other side did not challenge the invoice evidence during the trial.
Okay. Yeah, I will take this question. It would actually depend on the type of the legal fees. Usually, legal fees would be claimed under the heading of party and party costs, as I explained earlier. However, there has been a habit of claiming certain legal fees as special damages simply because such expenses were incurred prior to the filing of the suit. For an example, the fees for applying for pre-action discovery. Such legal fees have been awarded as special damages by the courts in various medical negligence claims. Apart from that, legal fees for applying grant of probate or letters of administration should properly be applied for under special damages. As for the lack of challenge in respect of legal fees, it is relevant. The courts would also ordinarily be guided by the complexity of the case. The court will consider amount of getting up and other factors. Yeah, so I hope that answers your question.
Thank you, Carmen. And to the second question that we have is the usual, which we get in all web medical legal claim. Can we have the slides after this session? Yes, you can. Or in fact, a recording of this webinar together with the slides will be uploaded on our website. So please keep a lookout on it because it will be posted after the session. Okay, and we have another question, Jeremy. With regards to the interest on the cost awarded, do we need a court order for that? And if the cost awarded is silent on the interest, can we rely on the Rules of Court 2012 to claim interest if the other party delays payment of the cost awarded to the successful party?
Hi. So in respect of this question, the answer is you don't need a court order for there to be interest, for the rule to apply in respect of interest to be applied in costs. That being said, I have had experience where when you seek payment and you include interest on costs, the other side, whoever they may be, may make the argument that this was not expressly ordered. You can point them to the rule, but they may resist anyway. So in the end, you may end up going before the judge for clarification, to amend the order, etc. I've been there. And it is actually to some extent simpler to just ask the court, just clarify with the court during the decision to say that its interest runs on damages and costs. As for the issue about delaying payment, yes, you can. In fact, it's one of that's why the interest is there in a sense, and it's quite beneficial. I've had cases where the damages were millions of ringgit, and the other side files an appeal, and they don't make payment despite various efforts to try and make payment. A year passed, and the interest was quite substantial. So yes, you can easily claim the interest runs until the last date of payment. Full satisfaction. So I hope I've answered your question.
Thank you very much, Jeremy. Okay, then that sums up our talk for today. And our next online talk would be on the 31st of May, 2023, on the Wednesday, on the topic of Industrial Court against Labour Court from our employment team. Our speakers will be Naveen Joshua and Kritika Padmanabhan. Also, do join us for our upcoming academic talk on mergers and acquisitions, benefits, getting it right, and the need for due diligence. This will take place on the 16th of May, and it will be a physical talk at TDI Global. Our partner, Cassandra Nicole Tomazios, together with our senior associate, Tommy Wong, will be presenting on this. This workshop will essentially cover all of the essential elements of a legal due diligence process, what a merger and acquisition is, the terms of a sale and purchase agreement, and the types of documents that are commonly used in such transactions. You may also follow us on our various social media accounts to get the latest updates on our talks and events. And finally, if you would like to speak with any of our lawyers, we offer a complimentary 30-minute consultation over the phone or virtually online. You may fill in the form by scanning the QR code on the screen or click on the link which will be posted in the chat below. And once again, to all our attendees, thank you very much for joining us. It is glad to have you here today. We hope to see you during our next online talk.